Evaluation of boat refugee policy of Australia. Australia is a party to International Refugee Instrument, and by agreeing to this convention, Australia has demonstrated generosity and humanitarianism toward refugees. However, the exception is the boat refugee issue. This paper focuses on the various policies and laws to deter the boat refugees which Australia has adopted. By using the shortcoming of international law and because there is no refugee determination procedure as per the 1951 Convention and the 1967 Protocol and no clear guideline in the refugee law about the disembarkation of refugees, Australia was able to adopt a policy of interdiction at sea. During the Tampa incident, the Australian government swiftly and harshly changed its refugee policy with the intention of not allowing a single rescued person on Australian land. Moreover, Australia uses its regional supremacy and shifts its refugee obligations to nearby poor and undeveloped states, Nauru and Papua New Guinea, in the name of a regional arrangement for refugee protection. Australia claims that it is respecting the spirit of the Bali process by developing regional cooperation arrangement on refugee protection. However, in fact, there is no burden sharing agreement. Rather, Australian regional arrangement indicate burden shifting. Moreover, if refugees attempt to reach Australia by boat, they are sent to the mandatory detention centers of a regional state in the name of the Pacific solution, which is against the spirit of international commitment. Therefore, Australia's refugee policy should not be a model for rest of the world. In fact, Australia's laws and practices toward the boat refugees has pointed out the gaps of international law and Australia has transformed those gaps into its domestic law. According to a new report 2019, due to Australia's stock interdiction policy at sea, since 2015, no refugee boats or undocumented migrant boats have managed to arrive in Australia's territory. On the other hand, the Labour Party, the opposition party, alleged that at the moment around 80 people are arriving daily by air in Australia and claiming protection visas, they are labeled the new boat people. From 2014 until 2015 to August 2019, almost 100,000 people who arrived by plane in Australia applied for refugee protection. But the government didn't focus on this new type of refugee flow. Rather, it always put the boat refugee issue on their political agenda. Asylum seekers by boat are being used as a political wage. Thus, it has been noted that government policy in this area isn't being driven by national security concern, but rather by a desire to continue using refugees as a political wage. Research data shows that in 2014 until 15, a total of 8,000 applications for protection visas were lodged by people who arrived by plane in Australia, and 9,000 applications in 2015 until 16. The numbers of plane arrival refugees doubled in 2016 until 17 to 18,000 and increased again to 27,000 in 2017 until 18. On the other hand, in 2012 until 13, at the peak time of boat arrival, a total of 18,000 applications were lodged by the boat refugees in Australia. In this regard, Labour's immigration spokesman Shane Newman alleged that the Minister for Home Affairs Peter Dutton's record-breaking number of onshore asylum claims cannot go unexplained, and he cannot wash his hands of his poor track record. Shane Newman also claimed that the government has taken its eye off the skies due to its obsession with boat arrivals. Another report noted that in 2008, a total of 4,000 plain people arrived by aircraft in Australia as legitimate tourists, business, and other visas holders, whereas only 161 people arrived by boat during the same period, which is around 96% less than the plain people. Moreover, the plain people are much less likely than boat people to be genuine refugees, with only about 40 until 60% granted protection visas, compared with 85 until 90% of boat people who are found to be genuine refugees. In this context, Professor Mary Crock, an Australian migration law expert, remarked that the boat people issue is old politics in Australia, which is politician expedient obsession. She also added that in general, a small number of boat refugees arrive in Australia, where nearly all are genuine refugees. The Refugee Council of Australia further suggests that asylum seekers are forced to flee, thus, it is not always possible to obtain travel documents or travel through authorized channels. According to the 1951 Refugee Convention, refugees have a lawful right to enter a country for the purposes of seeking asylum, regardless of whether they hold valid travel or identity document or are in Article 31. Consequently, refugees who arrive in Australia by boat are not acting illegally according to the Australia's commitment of the convention. Finally, this paper suggests that as a signatory state of the international refugee law, it is a legitimate expectation that Australia should act according to its international commitment toward refugee protection. Otherwise, deterrence policies and ignorance tactics toward both refugees violate Australia's international commitment and are an unlawful act in international law. Australia is a signatory state to the 1951 Refugee Convention and 1967 Protocol, which represent a positive approach to the international commitment on refugee protection. In the past, Australia showed its welcome policy to the Vietnamese boat people. It also developed its domestic law, Migration Act 1958, to ensure fair migration procedure. However, since 2001, Australia has demonstrated a restrictive view toward boat refugees. By adopting Operation Relax, Operation Sovereign Borders, the Pacific Solution, and the Maritime Act 2013, Australia has empowered its enforcement agencies to tow refugee boats from its territorial zone back to the country of origin. Australia has identified the gaps in international refugee law and operates within those gaps. Australia sends undocumented boat people to a safe country and concludes bilateral agreement to achieve this. Australia has also shifted its international commitment on refugees to other states through the Regional Cooperation Framework and the Refugee Resettlement Programme. Australia continues its negative attitude toward both refugees by sending them to offshore detention centers in the name of a durable solution for the refugee problem. The Tampa affair reflects Australia's harsh policy on both refugees. Although on several occasions Australian boat refugee policy has been challenged in the Australian court, unfortunately on every occasion the court supported the government policy and interpreted the refugee law from a narrow point of view, with the exception of the Malaysia Solution case. Therefore, under present law and policy, protection of boat refugees is a challenging issue in Australia, where international obligations are overshadowed by domestic law and policy, and this jeopardizes the international commitment and influences other states to take similar strict measures toward the boat refugees. Thank you.